It's a great pleasure to be here. One of the features of my time as Attorney General was that I always valued the opportunities to come over. Used to do it about 2 or 3 times a year in order just really to talk about areas of mutual interest. Northern Ireland's come on so much in the time that I've been in politics. It's an area that's always been of interest to me. In the past, I've been a member of the British-Irish parliamentary body. I'm a regular attender at British-Irish Association conferences in Oxford or Cambridge every autumn. And I have good friends over here with whom I sometimes come and stay. But of course, the big change that came in when I became attorney, it coincided exactly, was that justice was devolved to Northern Ireland. You acquired your new Attorney General, and as a result of that, my need to come over, what had previously been, in fact, routine visits by my predecessors, really once a month or once every 6 weeks, was no longer required. But I've still always enjoyed being able to come. And I've also been very conscious that there are legacy issues which have remained a responsibility for me when I was Attorney General, whether it be historic inquiries or indeed the problem of the on-the-runs which surfaced in the course of the last 12 months. And so many of these issues give rise to matters concerning human rights, a subject which is also of great interest to me, indeed of such interest to me that it may have contributed to my leaving government. But the fact that I've left government now gives me a slightly freer hand in terms of what I can talk about. And so when Les invited me over today and said, would I come and talk just a little bit about the operation of the convention, rather than just looking at the Human Rights Act or the work of your commission in Northern Ireland, it was a great pleasure for me to do so. And that really is my starting point. How is the convention working? The convention, I suggest to you, is really a very remarkable document. It goes back, as you know, to 1949-50, the immediate post-war period when the fears were centred on a return to Nazism or indeed to tyranny, and Western Europe was extraordinarily embattled as a little island surrounded by a sea of regimes on the east, all of which did not enjoy the rule of law or human rights at all. And as people are aware, it was quite controversial at the time the United Kingdom signed up. There were quite a few people over here who thought it wasn't a very good idea, wasn't in keeping with our national tradition, might offend the common law, and might impose, heaven forfend, a rules-based system that might be interpreted by foreign judges. All this caused at the time quite a lot of upset, and I suppose it's worth noting that so many years down the road, over 60, it still causes, from time to time, some upset. But the United Kingdom signed up, and I have absolutely no doubt that we signed up for reasons which were entirely compatible with our world outlook. We wanted to improve human rights on the continent. We wanted to make sure that there was no return to Nazi tyranny. And we also wanted to make sure that we were promoting a network of international obligations which raised standards between states and their own citizens, something which in truth we've been doing for a very long time. I once asked the Foreign Office how many treaties the United Kingdom had signed in the course of its history, and they weren't able to give me an answer before 1834, but they pointed out that since 1834 we had signed 13,200, ranging from, of course, the UN Charter to small agreements on fisheries with other states. And 700 of them have arbitral mechanisms within them which can be invoked for dispute resolution, which of course is exactly what the European Convention on Human Rights was all about, in setting up a court that could act as an arbitral mechanism if there was a dispute as to whether or not the individual member states were observing the terms of the treaty to which they had signed. And that's why we signed up. And I don't think we have any cause to regret it. I mean, interestingly, we carried on signing up to the protocols. We signed up to the right of individual petition, which has been such a dramatic change to the way in which the convention works. And we did it because we had a long tradition of liberty, and if you actually look at the 10 key rights enshrined in the convention, they were essentially the rights which most people in the United Kingdom would have considered to be birthright, something which you were entitled to have and would treat as a liberty and not as a right. But as we know, and perhaps I can say this, I mean, particularly in the Irish and Northern Irish context, it's one thing to have historic liberties which you're supposed to enjoy, but we all know that actually accessing them can sometimes be very difficult. And furthermore, there are plenty of examples in our national history of their having been violated without redress. So for those reasons, signing up, I think, was an immensely positive step. And those early judgments of the Court of Human Rights, whether it was Ireland and the UK over inhuman and degrading treatment, dare I say it, I'll come back to this actually at the end of my talk, something which perhaps the United States government should have read more carefully recently in terms of its own actions, or for that matter, Mark X and Belgium, where you're looking at a case involving the rights of illegitimate children, all really benchmarks that we would now regard as being absolute commonplaces in our own national discourse. And that's the extent to which the convention seems to me to have been effective. The moment, as you know, and I'll come back to this in a moment, the convention is a bit in for criticism over at Westminster. But I keep on trying to point out to my colleagues that they need to look at what the convention and the operation of the Strasbourg Court is doing on a day-to-day basis, particularly with those Eastern European states which, having come into the European family after the fall of communism, still have, unfortunately, bluntly, rather ropey justice systems and inadequate means of redress. Just look at a couple of cases in the last 2 years. Mammadov and Azerbaijan, the leader of the opposition group in Azerbaijan, imprisoned without due process of law for 7 years, with the government issuing a publicity statement before the trial took place stating he was guilty, and where in fact there was no basis for his arrest in the first place, no evidential basis of any kind at all. He was accused, having written a blog saying that the police had beaten up protesters, he was accused of having incited the riot in which the beating up had taken place. Violations of Article 6, violations of Article 5, and the court ruled in his favour. Or more recently, Avalkina and Russia, violations of Article 8 by the Russian government because the St. Petersburg Public Authority, the mayor and the corporation, decided to require hospitals to provide evidence of people who'd refused blood transfusions because they wanted to identify Jehovah's Witnesses and denounce them. That is, in reality, the day-to-day business of the Strasbourg Court at present. I know very occasionally there are cases involving the United Kingdom. There will doubtless be more. But it is worth pointing out that last year, 99.9% of claims brought from the United Kingdom to the court were sieved out and ruled as inadmissible at the first opportunity. The court currently is wrestling with the problems of Eastern Europe and is doing it very well. Now, one of the criticisms of the court is that it has allowed its workload to overwhelm it. There is some truth in that. In 2011, it had a backlog of 160,000 cases, and if any of you have been to Strasbourg, you can go down into the registry in the basement and you can literally see boxes of letters from people in prisons in Kiev and Siberia and Azerbaijan and Armenia, Romania, asking for the court to review their cases. All these have to be looked at. Some will be without justification, but others will require investigation. And so the court is, I suspect, in some ways, the victim of its own success. People have looked to it to provide remedies when they feel that other remedies are not available. The other problem it's had is it's said to be out of touch. And I think that that criticism can sometimes be justified. The difficulty is that when you start getting a backlog of 160,000 cases, the reason behind it is that you're not operating as the founders intended. It's worth bearing in mind that I think when the convention was signed, the thought was that the court might be involved in perhaps half a dozen cases per annum. Cases brought by one state against another, alleging, for example, violations of rights for minorities of one country that happen to be located in the other. Ever since we've had the right of individual petition, things have taken off. And I think that the criticism that can be validly made of the way in which the court has worked is that as it has acted more and more as a final court of appeal to so many states, it's been in danger of micromanaging the convention and trying to apply uniform rules. And as you'll be aware, that is not the intention behind the convention. Absolutely at its heart is the principle of subsidiarity, that it is for member states and for their own national courts to ensure that convention rights are implemented domestically, not to be acting as a court of appeal. And of course, in the United Kingdom context, that problem came to a head with the case of Hurst and the United Kingdom over prisoner voting rights. Now, I'd like to make clear to you, there are perfectly good and valid arguments to be advanced why prisoners should have the vote. A very charming Chief Commissioner of Prisons from Sweden came to see me last week, and I'm involved with the all-party penal policy group in Parliament, and he explained that in Sweden, every single prisoner, however heinous his crime, is entitled to vote at local and national elections. But I will say that it always seemed to me that the court was straying somewhat when it found that the United Kingdom's practice of preventing convicted and sentenced prisoners from voting during the course of their sentences was in breach of the convention, particularly as it has now sanctioned the system which exists in Italy, whereby although only some prisoners get deprived of the vote, they don't get it back when they get released without making, in some cases, an application to the court for the return of their voting rights. So they can, in some cases, be deprived of their voting rights forever. It just struck me that this was a bit of a sledgehammer to crack a nut. And, of course, it immediately raised the difficulties of parliamentary sovereignty. And I have to say to you, I think that whichever government is in power at Westminster, at the present time, I don't think they would succeed in getting through Parliament a law to accommodate or change and accept the judgment of the court, even if they wanted to do so and pressed for it very hard. And as Lord Judge, the previous Lord Chief Justice of England and Wales, pointed out, the court has to have some regard to the fact that countries with no written constitution like our own, and with parliamentary sovereignty as the doctrine, the problem can arise that if the court passes a judgment which the government knows it must implement as an international legal obligation, but Parliament won't do it, you do end up with an impasse that has to be resolved at some point, and the court must think these things through when it makes its decisions. But that having been said, it's always seemed to me that we need to remember in this context, if we criticise the operation of the Strasbourg Court and the Convention, that the number of cases where Strasbourg disagreed with our own national courts, where we now accept the Strasbourg ruling as being absolutely sensible. Think of Dudgeon about homosexuality in Northern Ireland. Not a subject, I point out to my colleagues, I receive letters of protest from nowadays, any more than Essen Harper against the United Kingdom on DNA retention, where the court overruled our own House of Lords. And in fact, I think most people now think that the judgment of the Court of Human Rights was absolutely correct, including within my own political party. So for those reasons, I hope I identified that I think the court, although it's faced with a lot of challenges, is not malfunctioning. It's simply trying to cope with quite a few difficult and challenging areas in its work. Now, when I came into government in 2010, Ken Clarke, who was then the Lord Chancellor, and I embarked on a programme of trying to achieve court reform. That culminated, it required a lot of legwork going around European capitals talking to our other justice ministers and indeed civil servants in those states, because there are 47 member states, so movement is difficult. But it did lead to the Brighton Declaration in 2012, a conference chaired by Ken Clarke, which I attended, which I think has introduced the potential for some significant changes in improving the efficiency of the court. Those are as follows. Firstly, we got the preamble of the convention altered to emphasise the fact that it is for the nation states who are the signatories to ensure that the convention principles are implemented in their own countries. And secondly, that the court in Strasbourg should always have regard to the margin of appreciation to be given to national courts, so that the fact that the court itself might have come to a different decision from the national court does not mean that the court in Strasbourg should feel itself under an obligation to overturn that decision, unless it thinks that the reasoning of the national court is in some way fundamentally flawed. As long as a reasonable case can be made, this is not a world of bright lines. This is a world where there are often grey areas and where, in fact, different national practices are part of the strength of the Convention and not part of its weakness. Thirdly, we've taken some steps, to try and deal with the backlog. And I'm delighted to note that the backlog is now well under 100,000 cases and going down. And that's simply because the court's introduced new ways of trying to scrutinise cases at an early opportunity and sift out what it is important and what it cannot address. And finally, last but not least, I think, a desire to try to improve the way in which the court operates through the quality of the judiciary who go there. Now, this is a sensitive issue because I have to say, from my own visits to the court, and I go over quite often, I certainly don't think that the Strasbourg court has inadequate or incompetent judges. But what I think is a valid criticism is that some of the judges are appointed from a background which is really rooted in the academic study of law and not in its practical application. And as all of you know in this room who are involved in seeing law being implemented, particularly through the courts, ultimately, if you don't have an understanding of the realities of implementation or of the problems of enforcing law, if, for example, you come from within a law enforcement agency, it's very easy to end up in a world where you can't see that the theory which you're trying to push in practice is going to be very difficult to deliver on the ground. Now, I have to say that I think that the United Kingdom is as guilty in a curious way in this context as any of the other member states. It's not that we don't have very able judges who we've appointed to the court. We do. But I think it is noteworthy that the last appointment, Sir Nicholas Bratzer, when he left Strasbourg, went into retirement. And it has always seemed to me that what we should be doing is aiming to see the appointment of judges to Strasbourg as part of a career process which sees judiciary selected and appointed who are also going to serve as judges in their own home jurisdictions and indeed on leaving Strasbourg may well be in a position to move to our own courts of appeal or Supreme Court. And the evidence, my view, is overwhelming that if we can get that sort of movement, not just for ourselves, but also for other European signatory states, then the chances are that the quality of the reasoning of the court is likely to become much more practically focused. And of course, the other feature which would be of huge benefit for the future is that it would also mean that we would have people with knowledge of the court coming back and serving in our own senior judiciary. And may I say, this could apply just as much to Northern Ireland as it could to England and Wales, or indeed to Scotland. In fact, it's very desirable that people who are thinking of judicial careers in any of the constituent parts of our country should think that the possibility for them is service within either the European Court of Human Rights, or for that matter, actually, we could profit from this with the European Court of Justice in Luxembourg as well. The other really significant change for me, which also gives me a lot of reassurance for the future, is that the way in which the Human Rights Act is being implemented domestically has, I think, changed significantly in the last 3 or 4 years. There's no doubt that when we put in the Human Rights Act, and I was one of, well, was a limited number of Conservatives, because in fact my party didn't vote against the Human Rights Act at third reading, but I was definitely supportive of incorporating the Convention into our own laws. But there's no doubt that one of the consequences of doing that is, in the first flush of enthusiasm afterwards, the House of Lords took the view that it had to essentially mirror decisions being made in Strasbourg. There was a case called Uller, and Lord Bingham, a very distinguished judge, took the view that that was the proper approach for the court. But this has now changed significantly, partly as a result of the anxiety that's been expressed that the court in Strasbourg was not always understanding some of the national subtleties of reasoning of the domestic courts. We've now moved to a position where, firstly, we've had quite a lot of criticism of the way the Strasbourg court works from our own judges. I can think in England and Wales of very interesting talks by Lord Hoffman back in 2009, Lady Justice Arden, more recently Lord Sumption in the Supreme Court, and Lord Judge, past Lord Chief Justice of England and Wales, each one pointing out that the Strasbourg court is in danger, as I was saying earlier, of becoming too much of a micromanager. And one of the consequences of this is that there is now what I would call a robust dialogue going on between the court in Strasbourg and our own courts, where our own courts will not necessarily accept a Strasbourg decision and just implement it if they get a subsequent case. We've seen this with a couple of examples. The first was the case of Khawaja, which was about the use of hearsay in our criminal courts. I mean, it's quite funny in a way, because at the time we signed the convention, we hardly allowed any hearsay to be used in our criminal courts at all. But we've moved quite a long way from that, but with safeguards. Khawaja called that into question, and our own Supreme Court in Horncastle rejected the court's interpretation in Khawaja, and it went back to the Grand Chamber. They accepted that the UK, or England and Wales, was compliant. And the other and more recent case, which I think is a very healthy pointer to the way this dialogue is working, is the one over political advertising in the Animal Defenders case, where, for understandable reasons, it seems to me, the court in Strasbourg was probably very anxious about this very curious British United Kingdom practice by which we prevent political advertising and we restrict it, particularly for third parties. But when they'd actually listened to the case which the United Kingdom government made as to why we do it, which is essentially to limit a free-for-all, raising massive expenses in election campaigns, in the Animal Defenders case, they accepted that it was a proper fetter on the rights under Article 10. My view is that, as things stand at the moment, the way the court is working seems to me to be pointing in the right direction. My recommendation is not that the court requires some massive overhaul. I would say more of the same, more of the direction of travel which it has already got. And in truth, there is little appetite in Strasbourg at the moment for further reform programme, because it's required a lot of energy to deliver the current round. And I think we're probably going to have to wait 5, 6, 7 years to see how things are working before people are going to want to come back to it. But I haven't been over to the court in the last 12 months. We did go over there to appear in cases, and I used to go over and hope I'll go back for further dialogue. But my impression is that in many ways, the court is more comfortable that it's able to do its work, and actually I think we should be more comfortable that the court is in fact achieving its goals. And as I said at the beginning, it's so important that the court should not be prevented from doing the work it is doing in those countries where, in truth, human rights are often very defective. It is a particular irony for me that at a time when my own party is calling into question whether we should be adherent to the convention at all, we are in a process where, in fact, we are devoting more and more national resources through DFID and overseas aid to human rights capacity building, because we see it as being an essential tool of soft power foreign policy. Rather unexpectedly, when I was Attorney General, I found that I travelled abroad much more than I had anticipated to go to the Gulf states to talk about human rights improvements in places like Bahrain, or to talk about dealing with corruption in government in Qatar, going out to deal with asset recovery and ensuring that you don't have kleptocracies at a big international conference in Morocco, or indeed going out to Afghanistan, where a lot of the UK's aid investment was towards capacity building for the rule of law, preventing people being beaten up and actually providing fair trial processes which weren't corrupted by drugs barons simply securing their own liberty through either paying bribes or intimidating the judges. So I suppose that brings me, last but not least, to the question of my own party's current proposals on the ECHR. As you will be aware, and anybody who wants to go onto my website and read what I had to say about this last week will see a rather longer critique than I'm going to deliver here today. But what I do want to say is this. Understandable irritation at the way the convention can sometimes prevent governments doing things which they think are in the public interest is not a good reason for chucking the toys out of the pram. The danger is that, for my party's proposals, is that firstly, it risks wrecking the operation of the convention on a European-wide basis if we pull out, which I think would be the inevitable consequence of the proposals. But moreover, it will do it for delivering what seems to me to be astonishingly few benefits, when you consider that, interestingly, my party is now sufficiently wedded to the principle of the convention that they wish to see any British Bill of Rights incorporate convention rights within it. But it's right to say that they want to dilute those rights in a number of key areas which I think are unacceptable. And this really brings me to my final point. I know that in the Northern Ireland context, issues of human rights, just as they are actually in England and Wales, can be very challenging. For example, I'm perfectly aware of where you are at the moment over questions of cakes being baked and what you're prepared or not prepared to put on the cake by way of an inscription in icing sugar. These are the realities with which we all have to grapple. The question as to where individual conscience should override equality and non-discrimination is one of those subtle issues of human affairs to which I think there is in reality no single answer. It has to be worked through. And indeed, in fairness, going back to the human rights framework that comes to us from the Convention, I suspect that whatever answer Northern Ireland chooses to come up with may well be compatible with the Convention, whichever it is. But the point about the Convention, and the point which I think my colleagues at Westminster are in danger sometimes of losing sight of, is it is indeed a living instrument. People may not like it, but if it's a dead instrument, it's not worth having. It has to be something which helps and facilitates a dialogue within our civil society that leads progressively to improving rights. You have a particular problem here because the structures of government you have mean that sometimes I think these debates are not taking place within the political context in which they would take place at home. So I'm afraid it chucks it on Les at the Human Rights Commission to take the flak, whereas we are more likely to have it within a political context at Westminster. But it isn't a reason why that debate isn't valuable. And I think if you look back over the 60 years that the Convention has been operating, what comes out for me is that most of the decisions or the progress that has been made are in areas that no one today would ever seek to reverse. So far from the debate and the polemic on issues of, for example, faith and discrimination being unhealthy or showing a sign that the Convention or our own human rights framework is dysfunctional, I don't think it is. It's a sign of that healthy sliding of the tectonic plates, which is precisely what a working democracy which is anchored in liberty should be all about. I said, I'm sorry to end on a slightly gloomy note, but I mean, I did read with great depression the account of the US Senate this morning and last night of what had happened within the CIA in terms of their violation of human rights towards the people they detained in Afghanistan. The United States is actually as fettered nominally as we are on Article 3 rights in respect of torture and inhuman and degrading treatment. They're signatories to the International Convention for the prohibition of torture. Indeed, one of the reasons why they can't empty Guantanamo Bay today is because there are some 67 of their inmates that they can't actually find a place to send them to because they know they would be tortured or ill-treated if they were sent back to their country of origin. And yet, this great state, and it is a great state, anchored in principles of the rule of law, nevertheless succeeded in committing such egregious violations of rights at a time when it was under pressure. And surely this is where there is a lesson to be learnt for us, not because I think the United Kingdom government is perfect in its actions or activities. As Attorney General, I've often had to grapple with all sorts of difficult issues. But I have to say that we now have a framework where I venture the suggestion that sort of egregious failure would not occur. Whereas before it existed, as we know from examples like the Mau Mau in Kenya, it almost certainly happened in similar fashion. And that, ladies and gentlemen, for me, is why the human rights framework we have is valuable. Not because it's perfect, not because it needs to be viewed as written tablets of stone, not because it can't be improved, and not because there won't be days when people will switch on the television and feel very angry about something which the Northern Ireland Human Rights Commission has just announced. But that's all part of that process of dialogue by which human society improves itself. And for those reasons, I'm very grateful to the work which the Commission here does, and I count myself very blessed that I live in a country where human rights are given such prominence. Thank you very much.